All right, Mr. Chairman, thank you.
Okay. Good morning, everybody. I'm going to call our April 28, 2015 meeting of JCO to order. I apologize for not being in Albany. Unfortunately, the train this morning was delayed by over an hour, and rather than keeping the commissioners, the staff, and the members of the public waiting for the train to arrive, knowing that we could WebEx from the New York City office, discretion being the better part of valor, not to the meeting. So my apologies for not being there in person. Here in New York is our new commissioner, Dawn Smalls. Welcome. And with that, I will call our attention to the first item of business, which is the minutes from our public session for a meeting on March 31st, 2015. Are there any comments or questions about the minutes?
I move they be accepted.
Is there a second?
So moved.
All in favor, raise your hand. In favor of adopting the minutes. Any opposed, raise your hand. Seeing none, the minutes are adopted. Before we turn to the report from our executive director, there's an item on the agenda, annual report. As the commissioners know, a draft of our 2014 annual report was circulated, I believe, yesterday to the commissioners. It's our intention to release that report at some point this week. We want to make sure that commissioners have an adequate time to review the report. So if you have any comments or questions about the draft report, please get them to the staff as soon as possible. And with that, I will turn it over to Letitia, who can give us an update on a number of items.
I just want to remind everyone that the deadline for filing your financial disclosure forms is Friday, May 15th. We have updated the FDS form to reflect the changes that were enacted in the most recent budget, and we've also modified the instructions. If anyone has any calls about filing their FDS, please don't hesitate to contact us as always. I'm now going to turn it over to Steve Boland, our Director of Administration, so he can give us our end of the year financial report.
Thank you. The end of the year fiscal report for 2014-15 are as follows. The commission spent $2,898,832 for the year, which represents 84.8% of the cash ceiling, which is $3,420,000. For non-personal service, the commission spent $728,689, which represents 8% of the non-personal service cash ceiling of $911,000. So overall, the commission spent $3,627,521, which represents 83.8% of the total cash allowance of $4,331,000. Are there any questions? Thank you.
Okay. Moving along, as I stated earlier, there have been some changes to the financial disclosure forms that were recently enacted, as well as other changes under our jurisdiction that affect our jurisdiction under the Lobbying Act. So at this time, I'm going to turn it over to our Director of Lobbying and Financial Disclosure Compliance, Martin Levine. He's going to give us a brief overview of those new provisions.
Thanks, Becky. I'll try to keep this brief. As also mentioned, there were a number of changes to the lobbying laws, the ethics laws, and the financial disclosure reporting requirements as part of the new FY15-16 appropriations, codified in Chapter 56 for anyone so inclined. They can be found in three buckets, if you will. One, the expansion of the oversight of local lobbying. Two, a new prohibition against the representation of private clients in connection with a bill or resolution. And then finally, 3, enhanced disclosure of outside income in the financial disclosure statement process. There were several changes to campaign finance, election laws, and other areas, but I'm not going to talk about those today as they fall outside the Commission's jurisdiction. Here we go. Before talking about the new local lobbying laws, I want to briefly summarize what constitutes local lobbying. As some of you can see on the slides, I apologize for not having those out to the WebEx folks. Local lobbying is any attempt to influence a governmental procurement, a law, ordinance, resolution, or regulation by a municipality, an executive order by a municipality, or a rate-making proceeding by a municipality. The clear definitional term there being municipality. Previously, it was any city, county, town, village, or special district with a population exceeding 50,000 or an IDA of the same jurisdiction, but school districts were explicitly excluded from that list. So what changed? The population threshold has dropped from 50,000 to 5,000, and school districts are no longer explicitly excluded. You can see how the scope of the law has expanded from this slide here. We went from 49 to 61 counties, leaving only Hamilton County as the one place where the Lobbying Act wouldn't cover local lobbying. 60 cities, 306 towns, 109 villages, 106 IDAs, and all of the approximately 700 school districts. So we're looking at a large expansion of local lobbying oversight in New York. The second major change after the Lobbying Act is the new prohibition on a public officer representing private sector clients for compensation in connection with a pending bill or resolution. This is Public Officers Law, Section 73-7-A, not to be confused with the financial disclosure statement at 73-A. This provides, like I said, no elected official, state officer, employee, or legislative staff member can receive compensation for the provision of services by themselves or by another related to a bill or resolution in the Assembly or Senate. It's fairly straightforward, but the key point, I think, here is that the individual cannot share in proceeds from this type of work, whether it was done by themselves or another. Violating this provision does carry a $40,000 civil penalty, plus the amount of any compensation received. Finally, the third bucket of changes is the enhanced disclosure of outside income in the financial disclosure statement. The changes that were implemented generally address 4 things across a number of the questions in the form. You're not going to find this all in one question. But as a public officer and an FDS filer, who are your private clients? If and how were they referred to you? What services are you providing, and how much are you getting paid for that? I'll start with the 2 provisions that are in effect now. That is, they must be included in your statement due May 15th. First, for the lawyers, and this isn't exclusive to lawyers, it covers other professions that are regulated by the state, but it's generally going to apply in the case of attorneys. In addition to disclosing that you practice law in the subject areas in which you practice, now the filer must also disclose the particular services provided and whether those services were provided directly to clients. That's going to be question 8A, and it is in effect now. The other change that is already currently in effect relates to how the filer reports his outside income. Previously, any income over $1,000 had to be reported and described, attributed to a source, and given a category of value. The law now explicitly requires that each source be described with particularity, as you see here in red. Without getting into any specific fact patterns, the touchstone principle, I think, to come back to here is who paid the filer and did it total more than $1,000? If so, the filer should disclose that entity and the nature of the income. Again, that's question 13 in the form, and that is in effect as we speak. Finally, the second set of FDS changes relate to disclosure of private clients. These changes are not in effect this year, as in you do not have to report these changes on your current form. The bill created 2 new questions on the form. That's going to be question 8B-1 and 8B-2. It also revamped questions 8C. So as I mentioned earlier, the questions attempt to elicit the following information about private clients: who the clients are, where they come from, how much is paid, and what services are performed. The questions are going to require different levels of disclosure based on a number of different variables: the amount of fees the client generates, the income the filer receives, how the client was referred, specifically was the client referred by a lobbyist, whether it was a matter in connection with a state contract or grant or agency case or proceeding, and whether the services were provided directly by the filer or to the client or by the filer to a firm. Interestingly, this year the statute provides a non-exclusive list of, quote, services provided for reporting purposes. And among those that they list are representation, advice, consulting, document review, preparation of financial statements, referrals, and commercial brokerage. So that's not all of them, obviously, but that's interesting that they've put that in the statute for the first time. Finally, under these new rules, the public official is entitled to apply for an exemption from disclosing a particular client under specific circumstances. JCOPE will be sharing some of that responsibility for the exemption process with the Office of Court Administration, depending on the type of client and the filer, and that'll obviously be implemented in the time before the filing's due next year. Again, these last changes that I discussed about disclosure of clients are not in effect for the current filing. That's all I have.
Thank you, Martin.
Thank you.
You can entertain a few questions.
Martin, yeah, let's have some questions.
Well, pardon my stream of consciousness, but let me start with the counties who dole out so-called economic development grants of various ilk. Is that considered procurement if an entity or an individual seeks one of these economic development grants from a county?
It's really going to depend on the structure of the grant, whether there was a competitive bid process and other factors that are considered. It's hard to say to any specific certainty without looking at the specifics of the grant. But you do want to remember that the statute defines public monies as something that falls outside the normal lobbying process, and we've looked at that as post-appropriation money, so that might weigh into the determination. And public monies reports are not required of all filers, are only required if the filer is already a registered lobbyist. So there's going to be a calculus that I'd be happy to walk through with you on any specific one, but
Just to clarify, there's a whole separate section on public monies, which I don't know that you're aware of, which relates to attempts to get grants, right?
yeah, outside the procurement process and the budget process.
Right, so it's a whole separate category of reporting that relates to grant applications.
Well, I won't.
So it's separate,
I won't belabor this now, but the soundbite is, if an entity is looking to get money from a county under the rubric of an economic development grant, then this is a category that will then trigger a filing requirement?
Maybe.
Maybe.
Yeah, it depends, there's a lot of
could.
factors.
It could. You still have the $5,000 threshold, correct, Martin? That would need to
But as I
be
mentioned, it's really
established.
going to hinge on the structure of the grant program, where it's, if it's coming from the agency versus the legislative body, et cetera.
All right, let me ask you to comment on question 8A. I want to make sure that my failure to fully understand is entirely my fault, but let me ask you, is the question fundamentally designed to elicit what the firm is doing or what the reporting individual is doing, or both?
Yes?
Yes, we have no bananas.
As you know, previously the question asked the subject matter in which the individual practiced. Well, we'll assume it's a practice of law in this
Right.
case. Previously, it was the subject matter in which the individual practiced, as well as the subject matters that the firm undertook, if the individual was a member of a firm. So,
Right.
what they're saying now is, for the case of the individual, not only must you describe the subject matter, but described the services provided, as well as whether it was provided directly to a client or to the firm indirectly. So it's an expansion. There's no elimination of previous reporting, but it's an expansion for the individual.
Very helpful, as usual. Thank you.
Thank you, Martin.
Any other questions?
Yeah, Dan, I have sort of, it's a follow-up actually to what Martin just gave us. It has to do, it seems that we have new responsibilities, or the responsibilities that we have been expanded. So my question is really going to how we're going to carry out those responsibilities and what the legislature has provided to us and the governor in terms of funds to do so.
Well, I think
Laura?
I can talk a little bit about that, Dan, just in terms of what, Chair, in terms of what we've been doing. With respect to the local lobbying provisions, we now have, new jurisdictions that the lobbying activity covers. So in anticipation of that, we have been reaching out to the municipal associations, coordinating with them. We are planning a webinar with the counties. We're going to be doing a lot of outreach to get them the information so they can comply with the new provisions. Additionally, we recognize that we're going to need to be hiring new filing specialists to handle what we anticipate to be a higher number of registrations from new entities that will now be covered under the Lobbying Act. So yes, we recognize that there's work to be done, and we intend to hire new staff.
Has the Division of Budget provided us with a certificate on the sub-allocations that are within our appropriation on personal service relating to this yet?
So I think, Steve, you might be able to help me answer this, but my understanding is that they haven't addressed the new funds.
In the appropriation, they added $1.2 million to personal service, but they confided in me that we have to determine whether we want to allocate any to non-personal service. And so they're waiting for a cash plan from us to determine how many people or how much funds we want to apply to personal service and how much to non-personal service.
And so staff has been working and discussing a potential spending plan and how we would allocate those funds, both in terms of should we make some NPS investments in terms of additional technology and tools that we might be able to use to accomplish our mission, as well as how many new lines we think we need to be able to meet the work of the commission. As Leticia mentioned, we see the need obviously for more filing specialists, but I think other additional staff is probably required in order to meet the new obligations and with the new FDS disclosures, the exemption process, as well as enforcement on both fronts.
This, because where I'm going with this is that, yes, the legislature gave us an additional $1.2 million.
Yes, correct.
We're going to need a certificate to go spend the money. We're going to have to get them a plan of salary, a schedule of
Yes.
salaries. But there was one more issue that has recently come up that concerns me. And it seems to be a process, and I'm not sure it's in law, that the Division of Budget's actually signing off on the people who we are hiring. And from a recent temporary hire, it seems that took several months. And,
And I know you've had some conversations, Monica, with
Yeah.
respect, to.
I mean, I'm not entirely sure what you're talking about. Yes, when we make a hire, it goes through budget, just as in any of our spending and appropriate. They get the BDA. We follow the same process that the Comptroller's office follows and that the Attorney General's office follows with respect to our hiring. I'm not aware of any position that took several months.
I don't want to get into the details here, but the point being that with 8 legislative appointees, I am I am uncomfortable with the Division of Budget getting to who we are hiring. Okay, I understand,
Well,
I don't think they're exercising any
Yeah,
discretion.
I don't think, excuse me, I don't believe that in the 3 years of our existence, this law changes anything with respect to the way that we're allocated funds, What's changed, thankfully, is that the governor saw fit, with the consent of the legislature, to substantially increase the amount of money that we have to do the vast scope of work that we have, which, as we all agree, is before the budget was enacted was quite broad, and now it's even broader. So I'm not aware of any changes in the way that the governor or the legislature intended for us to go about the process of making staffing decisions. So unless I'm missing anything, Monica or LT, I mean, why don't you comment on that, if you would?
Actually, Dan, I'd like to say something, because this was
Well, actually,
raised.
if you don't mind, I gave the floor, because I'd like to hear from the
D-
staff. I just want to make sure that if I'm incorrect, just let me know. Monica, LT, and then I'm happy to give the floor back to you.
There's been no
George.
change that we're aware of in terms of the process.
Thanks. Okay, I just,
Okay,
again,
now,
I just want
Dan-
to make sure I wasn't saying anything that was
Dan-
incorrect, but go right ahead.
Okay, no, Dan, I mean, this was raised at the first meeting of JACO back in December, well, actually, it wasn't the first meeting. It was the first meeting that the former executive director came in and said we were an executive branch agency. And several commissioners immediately responded that that was not the case. It's always been an open question.
Well,
I'm
I
sorry.
think in your view, it's been an open question.
I-
I'm not
I
sure
just-
how I would answer that, but in any event.
I'm sorry, it's my understanding is that we are clearly housed within the Department of State, which is within the executive branch. And as I was saying earlier, we are treated in the same way that the other departments that are not in the executive department are treated. So our hiring is done the same way as the Office of the Attorney General, the Office of the State Comptroller, and also the Commissioner of Judicial Conduct, which is similarly situated to us, that has various different appointees, but is in the executive department. So our hiring is done the same way.
Right.
It is not done the way that hiring is done within the executive department. And again, I'm not aware of any delay. My understanding from talking to budget is they just make sure we have the funds, and that's it. And it's usually about 2 weeks or less in the turnaround, if not even.
Not even that.
So there's no
Right.
discretion there that they're exercising other than we have the funding.
Correct.
And this is the same process that we've been following for the last 3.5 years.
And the reason we wait for BDAs from budget to hire is?
I think we just, they're verifying that the funds are there in order to pay the staff person, so.
Just like our purchase orders and everything else.
Well, I mean, the controller's system, once the cert is up, would not put more money, would not allow us to put more onto an appropriation than the cert would permit. Okay, so I'm finding, this process to be duplicative, and also could conceivably slow us down, but also concerned because of one of the recent hires that I thought took much longer than anticipated.
Well,
I'm
I
not
don't
aware
believe
of
we've had any delays in hiring folks, and I think the record is pretty clear, George, that nothing has changed. The law has changed nothing. We have the discretion on hiring. It remains solely with us. And to the extent that you have, a concern about the nuances of the budgeting process, perhaps we can continue that dialogue, with the staff. But I think you've heard from the staff that nothing has changed with the process. Discretion on hiring remains solely with JACO. If we have followed the process, which I think we can all agree has generally worked well over our 3.5-year existence in our hiring, we can continue with that. But as I said, to the extent that you have questions about some of the more nuanced issues which you're raising in the state budget process, perhaps we can have a conversation with the staff offline to get some more, to address those nuanced questions that you've got.
Thank you, Dan. I just want to make sure it is unfettered, because we're gonna be called upon to do a lot of things, and the last thing we need is snafus somewhere in the system.
Agreed.
Well, I couldn't agree more, George, and as usual, you've asked, very probing questions, but I guess, I'm a little surprised just because, as I said a few minutes ago, I think we should all be very pleased that the governor and the legislature have seen fit to so substantially increase the amount of money we have to meet our very broad mandate. That seems to me to be the headline, not about whether or not there's anything in the law that's changed our process, because I think it's pretty clear in terms of hiring that nothing has changed, and that both the governor and the legislature have vested broad authority with us to hire whoever we see fit. And so, as I said a minute ago, perhaps some of the more nuanced questions you have about the budget process, you should raise those. Certainly feel free to raise them with the staff at your convenience and at your leisure.
Again, Dan, we all appreciate what the governor and the legislature has done. One wants to make sure that no one else slows down what needs to get done in the name of cost savings.
Couldn't agree with you more, George. All right, any other questions or comments? Well, thank you, everybody, for a good and thorough discussion, and thank you, Martin, for your presentation. Unless there's other new or other business, I'd entertain a motion to enter into executive session pursuant to Executive Law, Section 9419B.
So moved.
For a second.
Second.
All in favor, raise your hand. Any opposed? Seeing no opposition, the motion is approved. We will enter into executive session. When the commission completes its work in executive session, we will report, we will return to the public session and report to the extent the law permits on our business during the executive session. Thank you very much. We'll now enter executive session.
Good thing I didn't have my golf clubs, because I'd be pissed. I could be on the first tee, but.
All right, we have returned to our public session. During our executive session, the commission approved an application for an exemption from the revolving door provision of Public Offices Law, Section 73, 8-B. The commission approved 3 settlement agreements. The commission commenced 1 investigation. The commission closed 2 investigations. At this point, unless there's any further business in the public session, I will entertain a motion to adjourn our meeting.
So moved.
There's a second. All right, so we have a move and a second. All in favor, raise your hand. The motion is carried unanimously. Thank you very much. We stand adjourned. We'll see you next month.